Welcome back to Sunrise. They continue our focus on the fight against corruption. Now we've got Mr. Joshua Aloba, who is a constitution and a human rights activist, also a lawyer. Good morning and thank you for joining us today. You've been doing some digging about all of this. First and foremost, about the judiciary. There's been a lot of focus on them for a while, but now that we have this kind of arrests making the rounds and allegations, even counter allegations making the rounds, do you think that at the end of the day, this will lead us to ensuring that, oh yes, finally, we can begin to cleanse the judiciary of corruption?
Thank you very much. And that is the positive aspect that I want us to look in the whole scenario. Instead of emphasizing or focusing on the technicality or the proprietary of the arrest or otherwise, the ultimate question should be who are the ultimate beneficiary of the war against corruption? It is the masses. And unfortunately, the masses have this web mentality that they cannot see beyond the immediate pains. And because of 1,000 or 2,000 you give to them, they have some form of solidarity in the social media, bringing a lot of questions that ought not to arise, because this beyond disputation that corruption is reigning in the judiciary. And I want to refer to what Justice Nikki Toby said as far back as over 10 years ago, or not even Justice Nikki Toby now. First and foremost, it should be from Kayode Esho. Kayode Esho, before the section 153 of the 1999 Constitution was incorporated in the 1999 Constitution, the provision of NJC was unknown to the Constitution. It was as a result of the endemic corruption that was in the system, and in a way to sanitize it inwardly without involving the security apparatus, that necessitated the setting up or the provision of NJC as an administrative body, not judicial body. It's very important, because the confusion that is at the public domain is that we will not be able to situate the difference between NJC as administrative body that allow the local standing or the various to try criminal allegations. So now, if Kayode Esho has in his report, which I'm going to read from my book, but I have to read the foundation, talk about how the corruption troubled the society. And in Olafusoye, the Federal Republic of Nigeria, the erudite and oracular jurist, Nikki Toby of blessed memory, also make a similar position. AG Federation and Ondo State versus AG Federation, 2002, the Nigerian Law Report passed 722, is to the extent that Nigeria was treated as a para-state. The constitution, the legality and the validity of ICPC Act was called to question because of Section 15 of the Constitution that provide that the state shall abolish corrupt practice. So the question of whether the federal government have the power to enact law that will have a geographical spread arose, and a lot of issue was canvassed. And the amicus curiae, especially Afe Babalola, gave his own opinion that corruption is not even limited to public office, that is pervasive in the private sector. So if Nigeria judiciary operate within the society, there is no way it will be...
Mr. Aloba, let me come in here, just a minute.
It will be exonerated from corruption. We are not saying that Nigeria judiciary is corrupt, but...
Okay, I was going to say that, because I thought you were painting all of them with one brush. You know, you can't do that, because in every sector, every facet of our society, you have a question or two, but not that you paint everyone with one brush. Now, about this fight against corruption and how we're going about it, ultimately, people want to see results. So, yes, you talked about the fact that we shouldn't emphasize so much on, you say, technicalities, but there's still the rule of law and not that of force. And things have got to be done as properly stipulated by the laws, because if you don't, and you get to the point wherein you have to prove your cases beyond reasonable doubt, it may fall flat on its face. And that will take us back to square one, having spent lots of money and raised a lot of expectation. To that extent, can't we then say that it's also very important we are mindful of that?
In as much as I say we should not look at the technicality, because in the first place, DSS operation is within the ambit of Administration of Criminal Justice Act, which is applicable in FCT. Section 149 is to the extent that on how search warrant can be executed when there is resistance. So in the house of Honorable Justice Sylvester Guta, there's no evidence that the property was pulled down. In the house of Justice Okoro, there's no evidence that the property was pulled down. So the fundamental question, why did they pull down the outer door, which is provided in the extant law, when there's a resistance to search of premise? The security agent, the laws provide, section 149, that the police or any security agency can pull down the outer door. So the dramatization of this issue is to bury the substance. All right, Mr. Lobo. As much as what the DSS has done.
Just hang on a minute. We will come to you and get your response, at least, so that you can conclude in just a moment. To join us again.